Good morning. Happy Wednesday. So this dropped in the middle of the night. This is Jose Maria Decastro's first amended complaint. He didn't do any of the things that I was kind of expecting him to do, so that's good. I mean, keep people on their toes and everything. He added does 1 through 50, so that's going to be interesting, or not. I don't know how this is going to shake out. Like there are so many possibilities on how this is going to shake out. The mind reels. It's very hard to figure out how this is going to shake out. Other than this First Amendment complaint is most likely going to be dismissed with prejudice. So there's that. Anyway, it's his First Amendment complaint. Jose Decastro, brings this complaint against YouTube publishers Josh Abrams and Kate Peters, and John Doe's 1 through 50, and allege as follows. Introduction. This is a case about the ongoing and wholesale copyright infringement of my video content by defendants Peters, Abrams, and others currently known only by their YouTube channel name or URL. I teach constitutional law and am attempting to tear down some of the racist laws in the country, which invites hate and offers opportunity to those that profit on hate. That was a garbage sentence and had nothing to do with anything in this pleading, so I don't even know why he put it in there. As part of my teaching and as a revenue stream, I create video content and publish it on YouTube. He could have just said, I create video content and publish it on YouTube. That's all he had to say there. Defendants, to save from having to create content themselves, are, in a word, stealing my content on a grand scale. That's actually 7 words. 1, 2, 3, 4, 5, 6, 7. That's 7 words. That's not a word, Jilly. If you wanted to use a word, defendants, to save themselves from stealing content, or to save themselves from having to create content themselves, are, in a word, thieves. That would be a word. This is 7 words. I know you're trying to wrap it around your head, buddy, but yeah. Defendants, to avoid creating content themselves. See, using passive language like this, having to create, you want to use action verbs. Creating. To avoid creating content themselves. You don't want to use having to create. That's weak. It's weak writing. But you're a weak man, so I guess, that's what happens. They publish content to YouTube that largely only copies my content for monetary gain in the same YouTube content market and without my consent. I have never seen Kate Peters not do fair use with your content, but I will be honest with my audience. I don't watch a whole lot of Masshole Mafia. I mean, I really don't. I have watched very few of their live streams. It's not my bag, baby, to watch a lot of live streams. I mean, I could barely do it for Chili. And any video that's really over about 10 minutes long really taxes my ability to pay attention to it and my desire to watch it. I mean, 30 minutes is like a real almost hard shut off for me. So I try to keep my content to be about 10 minutes or less. And it's only things that have to go longer that I make longer. Insert joke there. So I have not watched a lot of Masshole Troll Mafia. I've watched a little bit, but not a lot. And on what I've seen, I've never seen them just play your content without commentary and critique. This is a civil action, he says, seeking damages under the United States Copyright Act of 1976 as amended, 17 U.S.C. 101 sequitur, the Copyright Act, and the Racketeer Influenced and Corrupt Organizations Act. So, spoiler alert, he doesn't actually plead any causes of action about RICO, but okay. Jurisdiction and venue. It is a federal question. And if it was RICO, I don't know if they'd have federal questions because he doesn't actually plead RICO, so I don't care and I haven't looked into it. He pleads RICO again. Again, I don't know if it's proper for RICO. Doesn't matter. Haven't looked into it. Parties. I, Jose Decastro, am an individual residing at 1258 Franklin Street, Santa Monica, California. Defendant Kate Peters is an individual and a YouTube publisher residing at 47 Avery Street, Apartment 1, North Attleboro, Massachusetts. Defendant Joshua Abrams is an individual and a YouTube publisher residing at 21 Valley Road, Stoneham, Massachusetts. I can only identify John Doe's 1 through 50 YouTube publishers by their YouTube channel URLs. And he doesn't. He does not identify them by their YouTube channel URLs. He doesn't identify them, period. So that's interesting. Not that it matters. This is going to get dismissed anyway, but whatever. Factual background. I have published over 800 videos to which I own the valid copyright to as content to my YouTube channel at this URL. This is the URL to his main YouTube channel. Now, I don't know if he has a valid copyright to anything. He doesn't have a registered copyright to anything. I'm going to assume he has valid copyrights. I don't think you need to have a registered copyright for something to be, effectively copyrighted by you. But I'm pretty sure that you have to have a registered copyright in order to bring a lawsuit on it. So that's going to suck for him. I earn revenue when these videos are viewed directly from my YouTube channel. Defendant YouTube publishers have copied large portions of my copyrighted content on their YouTube channels. Many of the defendants make money from copying my content onto their YouTube channels when my content is viewed on their channels. All the defendants are in the same market of YouTube content creation. Defendants profit from my content simply by using it to save them time and money and the effort of creating their own content. My copyrighted works are listed in Exhibit 1 in any supplements by URL, by YouTube URL. And these are all of them. These are all his videos. Look at all those videos. Now, he doesn't say anything where he hasn't cited any of their infringements, but whatever. Count 1, the only count, by the way. Copyright infringement. The allegations contained in paragraphs 1 through 19 are hereby realleged, as if fully set forth herein. I'm the owner of valid copyright of the works. The works are original work of my authorship. The defendants copied and distributed constituent elements of my works. At no time did I authorize, permit, or consent to defendants' distribution of my works, expressly or otherwise. As a result of the foregoing, defendants violated my exclusive right to a. reproduce its works in copies in violation of 17 U.S.C. 106 and 17 U.S.C. 501. Distribute copies of the works to the public by sale or other transfer of ownership or by rental, lease, or lending in violation of 17 U.S.C. sections 106 subsection 3 and section 501. Perform the copyrighted works. They performed them. They performed your videos. Words are hard. In violation of 17 U.S.C. 106 subsection 4 and section 501, by showing the works' images in any sequence and or by making the sounds accompanying the works' capable and transmitting said performance of the work by means of a device or process to members of the public capable of receiving the display, as set forth in 17 U.S.C. Section 101's definition of perform and publicly perform. Display the copyrighted works. They displayed the copyrighted works in violation of 17 U.S.C. Section 106, Subdivision 5 and 501 by showing individual images of the works non-sequentially and transmitting said display of the works by means of a device or process to members of the public capable of receiving the display, as set forth in 17 U.S.C. Section 101's definition of publicly display. Defendants' infringements were committed willfully within the meaning of 17 U.S.C. Section 504C2. Request for relief. I request the court A, permanently restrain defendants from continuing to infringe my works. B, order the defendants delete and permanently remove the digital media files relating to my works from each of the computers under defendants' possession, custody, or control. C, order that defendants delete and permanently remove the digital media files containing copies of my works that defendants have on computers under defendants' possession, custody, or control. D, order that defendants remove all media files from YouTube containing copies of any portion of my works from YouTube. E, award plaintiff statutory damages per infringed work pursuant to 17 U.S.C. Section 504A, and C, award plaintiff its reasonable attorney's fees and costs. Again, you don't have an attorney, you moron, pursuant to 17 U.S.C. Section 505. He might get filing costs, but he won't get attorney's fees because he doesn't have an attorney. I don't care what discussing law says, that guy's a moron. You don't get attorney's fees if you don't have an attorney. Grant plaintiff any other and further relief this court deems as just and proper. Now, again, the problem, as I've said, is that you have to have a registered copyright in order to file. Now, I believe you can register it. I could be wrong. I'm not a copyright attorney. It's not what I do. I've never done a copyright case, except I was sued by Earl for copyright infringement. So I did look into a little bit of it then, but his copyright case, he had actually gotten a registered copyright on the work that he was suing me over. So I didn't really look much into that portion, but it is my understanding and belief that you have to have a registered copyright in order to prevail. You can, I believe, pre-register it or start the registration process when you file, but you have to show the documentation that it is registered or in the process of getting registered when you file the lawsuit, and he didn't do that. Jose didn't do that. And I don't believe that he alleges in here that he owns a registered copyright on them or that they're in the process of being registered. So I don't believe that he has I don't believe he's stated a claim. Now, for those of you who thought that once Kate and Josh filed answers that he no longer had leave to file a first amended complaint, or he no longer could file a first amended complaint by matter of right, we're going to find out. I believe he could. How is this going to affect things currently? Well, I believe this is going to moot his request for dismissal. He's filed a first amended complaint. I believe this is going to moot the whole ECF thing. I believe all that's gone because he was trying to dismiss it, but then he filed a first amended complaint, which indicates that he is not trying to dismiss it. So my best guess is that is gone. The motion for contempt, I believe, is still in play. At least in theory, it's still in play. I don't think that's going anywhere. And my best guess on what will happen is that the defendants, the named defendants, Josh Abrams and Kate Peter, will file 12b6 motions to dismiss, and this will go away very quickly. Now, there's lots of theory out there. There's a lot of theory crafting on what Decastro's motive is. Apparently, he had said previously, and I do want to thank the autists in my Discord for coming up with some of these theories, because I have a real hard time figuring out what Jose's angles are, because he's not rational to me. I don't think the way he thinks. I have a very hard time to place myself in his position and figure out what he's trying to do, because he's so unconventional. Attorneys don't work the way that he's working. You know, we normally have some constraints of, ethics. I know that sounds weird to say, but we actually have like rules of ethics governing our behavior, at least as far as our actions in and around representing clients. So, Chili's not bound by any ethical constraints. He is not necessarily trying to win. He's trying to just waste as much money as possible. And, attorneys love to get paid, and we like to bill and do as much work as the client will let us do. But ultimately our goal is to get the result for the client that the client wants. So like none of this really makes sense. It's very hard for me to place myself into Chili's position. So I do want to thank the people in my Discord who have been speculating about this all morning. But there was, and I believe it was a tax attorney who came up with this. I could be wrong. If I'm misattributing this, I apologize. He came up with a line from a previous pleading from the motion to dismiss, where Chili basically said that he could amend his complaint to have the existing claims removed from it, and then have the first amended complaint dismissed with prejudice, which means that the claims that were amended out of it, they're not dismissed with prejudice because they're no longer part of it. Now, there may be some abusive process there. 41, Federal Rules Civil Procedure 41 might still come into play because he is dismissing it. You could make an argument that he's dismissing an action by filing a first amended complaint that removes the existing theoretically valid causes of action and substitutes in an invalid cause of action for the purpose of getting the complaint dismissed so he can refile in California. That is a possibility. I mean, I don't think that this is going to prevent the defendants, if he does refile in California, from seeking to have reimbursement from him for the action in Massachusetts before the California process can go forward. I'm not saying that it is possible, but I'm also not saying that it isn't possible. An argument could be made. I think a valid argument could be made. And I haven't done any research on it, so I mean there might be a case on point, but I don't know it. I'm just familiar enough with the propensity of the courts to look at things like this and say, you told the court you were going to be an asshole and try to skirt the rules, and then you just used a procedural trick to skirt the rules, and now you expect us not to realize that you just used a procedural trick to try to skirt the rules. And courts don't fancy that very much because they don't like to have people waste court time and court resources by doing stuff like this just in an attempt to skirt the rules. So I have a feeling that there is going to be a way to sanction Chili if he does try that, and he might well be trying to do that. Again, if he does try to refile in California, he is going to have to reserve Kate and Josh, and he's going to have to establish personal jurisdiction over them in California, and I don't think he's going to be able to do that. It's theoretically possible with Kate. It's next to impossible with Josh. So there's your little bit of Nostradamus for the morning. I have no idea what he's going to do, but this first amended complaint is a loser, and I think it's going to go away fairly quickly. Thanks for watching. Have a great day.